Okay, good afternoon, everyone. Thank you very much for joining us for this seminar of discrimination in public law. This is one of Doughty Street's series of seminars about discrimination to celebrate 10 years of the existence of the Equality Act 2010. This seminar is focused on public law discrimination, and we've got 4 speakers. We're all very conscious that the England match is due to start at 5 p.m. And so we're going to try and finish much of the talk before 5 p.m. There will obviously be live updates if our talk goes on beyond that, and potentially we'll try and do some replays of any important parts of the action as well. We have 4 speakers today, and we're going to aim to have 15 minutes or so for each speaker. If it's unless there's anything particularly urgent, we're going to aim to have questions at the end of all 4 speakers, or if you'd like to send questions through the messaging board, then please do feel free to do that as we go along. The first talk is by Shushin, who is a barrister at Doughty Street. Shushin is a public law barrister. She practices in a broad range of topics. Recent successes include the Napier Barracks case. She represented children in a challenge to the extension of custody time limits. She was involved in the Dodana case in the Court of Appeal, which is an important case about the PSED, and also in the case of MN, which was about the assessment of credibility of trafficking victims, among a number of other important recent cases. And she's going to talk about discrimination on grounds of other status. So I'll hand over to Shushin now.
Thank you, Adam. So my talk is on Article 14 and status, and the key thing is, right, if you could do the next slide, please. Yes, thank you. The difference between Article 14 and domestic framework for the Equality Act is that discrimination is prohibited on any ground, such as, and it's not a closed prescribed list. And you can see that at the bottom of that slide. Also, it's not based on a defined concept of a protected characteristic. And it's much more flexible because of the reference to any other status. Next slide, please. The test currently as stands is the test in Clifton, the UK. The words other status has generally been given a wide meaning. Interpretations has not been limited to characteristics that are personal, so in the sense that they are innate or inherent. For example, sex, gender, age. And that's confirmed in Stott and the Secretary of State for Justice, which adopted the Clifton UK formulation and departed from the old House of Lords case of Clifton, the Secretary of State. And in some sense, some domestic courts judgments have questioned whether other status and the stage that is always disputed, particularly in social security cases, is even necessary as a separate requirement to establish Article 14 discrimination. And you can see on the screen the cases of Stevenson and Matheson, both high-level cases, casting doubt as to whether or not there is a necessity to wring hands over this particular stage of discrimination. Next slide. But then what actually does any other status mean? And the case law, although has been developing over the years, what I'll show in this short bit of the talk is that the state of the law is clear as mud. The boundaries are really just not clear at all. And you can see that in one of the most recent cases, Bloomsbury Institute Limited and the Office for Students. And that, well, the description of it being complicated and difficult, actually it's because it's exactly as the Court of Appeal and Stevenson identified, is that really, are we talking about status as a freestanding concept? Does it bleed into differential treatment? Or is it really ultimately a question of justification? But Lady Hale in Stott, which is a Supreme Court authority, said, you know, be that as it may, you might have a generous approach. It still needs to be tied to discrimination. It needs to be tied to test the other parts of the test of discrimination. So next slide, please. So for example, in SC and others, which is a 2-child limit challenge in respect of whom, child tax credits can be got and can be payable, Leggett said at paragraphs 72 to 77 that status has to still be capturing the entirety of the discrimination alleged. So in that case, there were 2 ways in which status was put. I mean, Carla will correct me because if I'm wrong, but one is a child with multiple siblings, so more than 2 children in the family. And Leggett rejected that argument that would constitute a status for the purposes of that challenge to whether or not you could limit child tax credit or universal credit to 2 children. Because non-siblings would be captured and siblings for whom adults are not responsible won't be captured. So he went with instead household or family, which is looking at the living circumstances of a household, and in that context affirmed what was said in Stott, which is that the status doesn't need to be innate or inherent as part of a person's personality. It could be part of their circumstances, living situation on which a legal consequence depends. Next slide, please. And this really kind of follows through with what Lord Walker famously coined the concentric circles of personal characteristics. So you've got 3 circles, starting with the innermost circle of innate and close connection with personality, gender, sexual orientation, pigmentation of skin, disability. And then you move to a wider circle of development of personality, so your nationality, your language, your religion, and your politics, and to the very outer circle, which are characteristics concerning what people do and what happens to them rather than who they are. And that could be homelessness, residence, domicile, or in the last 2 years, you've also got the Court of Appeal case of JT finding a victim of violence to be on that outer circle, but still nevertheless a status. Next slide, please. But one of the difficulties is the question of whether or not the status has to be something separate and different and independent of the differential treatment alleged. So in the case of Clift and the Secretary of State, Lord Bingham said, yes, it does have to be. In that case, it was about early release provisions and when the parole board can review, and whether or not the difference in timing of when the parole board would review rendered it discriminatory to certain people with certain lengths of sentences. And what Lord Bingham said, without really explaining it, is that what you're alleging as a status is exactly what the differential treatment is. And if the 2 are overlapping in the way that they are, it can't be a status because it's not separate as a separate ingredient of discrimination. When the case reached the Strasbourg court, Strasbourg said, no, actually, that's wrong. Whether there's a difference of treatment based on a personal identifiable characteristic in a given case, it has to be assessed in all the circumstances. And bearing in mind, and this is where it perhaps is slightly different to the Equality Act framework, is that it ties back to Article 1 of the Convention, which is to guarantee that rights are not just theoretical or illusory, but practical and effective. And if you find that there is no status established, then you don't go on to consider the differential treatment and the discrimination and the justification. And the case collapses at that stage. That, in Strasbourg's view, actually doesn't give practical effect to rights. In Doherty, however, notwithstanding Clift, the Supreme Court said the difference of treatment in that case alleged is the change in the sentencing regime affecting a particular group of prisoners. But because the differential treatment is essentially the status that's claimed, it's entirely about differential treatment, so the status isn't established. Next slide. To make it even more confusing, you then get Stott, which was 2018. Doherty was a 2016 Supreme Court case. So 2 years later, a similar consideration on status and whether or not, in the context of criminal justice, certain categories of prisoners would enjoy other status, came before the Supreme Court again. And in a 4-1 majority, the court concluded on the facts of those cases that those prisoners who served extended determinate sentences and had a different timing for when they would be considered for parole, an early release, enjoyed a different status to other prisoners that had an earlier consideration of early release and parole. And what Lady Black said is she deprecated the criterion of independent existence, and she had a long discussion on why that is the case, but ultimately looked at Doherty and said, well, Doherty may have been decided in the context that it has been, and perhaps may have been correct. She didn't actually say specifically, but she said it couldn't stand in the light of the long standing Strasbourg case of Clift in the UK. Lord Hodge said the status tests had been met, but he didn't really wanted to go into any comments about Clift and Doherty. Lady Hale said status tests had been met, but that Stott was stronger on the facts than Clift. Unclear what that exactly means. And Lord Mance said no, there's no reason why a person may not be identified as having a particular status when the or an aim is to discriminate against them in some respect on the ground of that status. But all of them effectively, it's not really helpful to have 4 majority judgments, all saying slightly a variation of the same thing, but not really coming out to say either one way or the other whether Doherty was rightly decided or wrongly decided in the light of Clift in the UK. So the law is slightly left in a bit of uncertainty after Stott, because ultimately, if you look at Lady Black's Liege judgment, she did say at paragraph 75 that, well, whatever the debate may be about independent existence and that being a criterion, it was met anyways in the context of Mr. Stott. Next slide, please. So what's left after Stott is that you do end up having a bit of a tension between the need in the context of Article 14 language to identify the ground, so the other status for which you're saying that there's a differential treatment, and that this differential treatment at that ground cannot just be a description of the differential treatment, because otherwise it becomes a little bit circular. And that's clear from what Lady Hale said in Stott, and that's also clear from what Lord Justice Leggett said in SC. And the same approach was identified in Simwawi. But on the other hand, you also have a deprecation of the independent existence criterion. So there is really a tension between the two as to, well, how then do you define where the boundaries are for what constitutes an other status and what doesn't? Next slide, please. So if you I had a look again at some of the cases that I thought really did test the boundaries. If you apply this concept that the discrimination alleged can't be the thing that describes the status. So if you look at Matheson, what was complained there is about the difference between children who are in hospital for less than 84 days and those who are in hospital for more than 84 days. Those in hospital for more than 84 days lost their disability living allowance, and then those who didn't. And the status and the difference in the status is a child hospitalized free of charge in an NHS hospital for a period longer than 84 days. In Pollock in Slovakia, which is the case that was relied on by Strasbourg in Clift in the UK to reject the government's argument about the independent existence criterion, that was a case where the applicant was the father of a child who could not disprove paternity by DNA testing. But the issue complained of there is whether or not you needed DNA testing in order to prove or disprove paternity. And again, so those are 2 cases where there is a very close alignment between the differential treatment and status, and yet nevertheless, the courts have said there is an other status established. Compare that with the case of Minter, which is often cited in cases defending allegations of status. And that was a case very close to Clift and very close to Doherty, which is about a sentencing regime introduced by new legislation to offenders sentenced after a particular date. And that was said not to be a status. And if you look at HC and the Secretary of State for Work and Pensions, being a Zambrano carer was also not said to be a status. So if you look at and contrast the cases that test the boundaries and the cases where status is not established, it's quite difficult to see where the line is actually drawn and where the boundary is. Next slide, please. So just stepping back a bit and looking at the post-Stott landscape, I would say there's sort of three strands of approaches by the court, which is also why I started off by saying that the law is clear as mud. You've got the broad test under Stott applied in subsequent cases. You've also got a second category of middle ground cases where the court has just decided, well, status is just a bit too complicated. Let's just assume it's made out and let's skip on to justification and proportionality. And then you've got the third approach, which surprisingly, despite Stott, sorry, that's not Stoff, it's Stott, the court was still applying a restrictive approach. And so I just want to have a quick look at those three before wrapping up. Next slide, please. So I've already touched on SC, but it's quite interesting what Leggett says in SC and why Leggett decided that a family or household was in other status in the context of the two-child limit challenge. Because he accepts the premise of his approach is that the status doesn't need to be innate or an inherent aspect of an individual's personality. So it doesn't have to be that inner circle of Lord Walker's concentric circle. But what he does say is that how far outside the circle you go affects your relationship with consideration of justification. So the further out you go, the more unlikely it's going to be of a sensitive or suspect kind of classification, justification, and discrimination, which requires weighty reasons. And you can see a similar broad approach in the case of AR and others, and the Secretary of State for Work and Pensions, another recent case, where in that case, the status is a severely disabled person who moves home across a local authority boundary, and that constitutes a relevant status. And in a very similar way, the Court of Appeal there adopted a very similar approach to Matheson by focusing really on the severe disability rather than worrying too much about the fact that the descriptor is the residence and the relocation and geography. Next slide, please. So in the second middle ground category, you've got DA and the Secretary of State for Work and Pension, which is the benefit caps case. And the courts, the majority of the Supreme Court just assumed that applying a broad meaning of other status under Stott and Clifton in the UK, all those statuses, lone parents of children under a certain age, and the children under a certain age are relevant status. And there was not very much discussion about the issue of status. The case really turned on consideration of justification. Again, in Ekbar, there was an assumption that the status as an ARE, so or appeal rights exhausted prisoner, would be a status, although there was some debate and the divisional court was unwilling to come down one way or the other and simply say, let's assume it, let's go on to justification and proportionality. In Moore, another recent case, Mr. Justice Swift also proceeded with some unwillingness, but nevertheless proceeded on assuming that women in receipt of maternity allowance is a sufficient status. But again, like Lord Justice Leggett, he thought the quality of the status and how far out you go in terms of the concentric circle, although he doesn't use that analogy, would affect how you approach the question of justification. In that context, he thought that actually you could just completely reformulate the question on justification as a rationality question, as opposed to a very structured proportionality exercise. Next slide, please. And finally, you've got the very restrictive approach in the case of Aaron Banks and the HMRC. And that was a case where the complaint was discrimination because he was a supporter and donor to UKIP, and they failed to achieve an elected MP. So he didn't get a tax exemption. So he sued the HMRC. Although in that case, the conclusion was that the status was too much aligned with the differential treatment complained of and didn't have an independent existence. And the upper tribunal in that case went to great lengths to say that in any event, Lady Black's judgment on independent existence not being applicable and deprecation of it was really obiter, because at paragraph 75, she found in any event that Mr. Stott met that criterion. But really, I think in that case, in truth, is that the other status relied on is, as Lady Hale says, is impermissible, is merely a description of the differential treatment. So it does still need some distinction between the differential treatment and other status. But exactly what needs to be distinguished between the two is really clear as mud. Thank you.
Thanks very much, Shushin. That's great. And also thank you for the 2 questions in the chat from members of the from the participants. As I say, we'll come back to them at the end. I think we'll probably deal with one of them actually during the talks. The next talk is by Carla, who's the head of strategic litigation at CPAG. She's one of the leading lights behind many of the most important cases involving social welfare and benefits. For example, she was involved in the Supreme Court decision DA about the lowered benefit cap, in the case of SC, the 2-child policy, which has been heard at the Supreme Court, but judgment hasn't yet been delivered. And also other aspects of the universal credit system, for example, the Court of Appeal case of TD. Carla's going to talk about key recent and pending discrimination cases, and also the role of the United Nations Convention on the rights of the child. Thanks very much.
Thanks, Adam. I'm afraid my talk isn't as detailed as Shushin's was, so it's really an overview of social security cases in the last 2 years. So I've been at Child Poverty Action Group now for almost 5 years, and in that time we've had 4 cases which have concluded in the Supreme Court. We've had 5 which have concluded in the Court of Appeal. We've had 1 that's concluded in the High Court, and we've had 4 upper tribunal cases, all dealing with Article 14 discrimination. So the first question is, why are social security challenges rife with Article 14 discrimination claims? And the answer to that is because there's no general right to social security under domestic law or the European Convention on Human Rights. You can't simply argue that non-payment of benefit to X group breaches their right to social security. Instead, you have to bring a contorted analysis that the non-payment of benefit to X group or payment on worse terms on the basis of a particular status means that they're being treated worse than Y group who are in an analogous situation, and that difference in treatment is not justified and so breaches their right to non-discrimination in conjunction with a substantive ECHR right. Yeah. So, and then in relation to some of the questions that are coming through on the chat, there's reference to Equality Act, and the cases that we've been involved in are challenges to legislation, and those can't be brought under the Equality Act. There's an exemption in relation to that. So our discrimination claims are Article 14 claims. So in view of the number of Article 14 cases that I've been involved in, and in view of what Adam said in terms of some of the light that we've been doing, you'd think that I was an expert on Article 14. In a lot of ways, I feel very much anything but an expert, and that in some ways you feel that you've got a grasp of it, and then the parameters move or the goalposts move. And I think Shushin's talk on status and how things are clear as mud illustrates that. So providing an overview of the last 2 years, if I was to have given this talk 2 years ago, I'd very much be licking my wounds. Yes, we'd have just had the decision of the Supreme Court in DA-DS, the lowered benefit cap case, which seems to have been hijacked by their lordships to pronounce once and for all on the Article 14 justification test, and that this was a single, manifestly without reasonable foundation test, which raised some concern as to whether the 4 stages of justification, i.e. whether there was a legitimate aim, whether there was a rational connection of the measure to the aim, whether there was an inability to achieve less intrusively what was being sought, and whether there was a fair balance between all interests in play, whether those four strands were even in play anymore, or whether it's just a single comprehensive manifestly without reasonable foundation test. And so, there was concern about the way the case had been hijacked for pronouncement on that, but also for for CGPHE's purposes, a real concern that how a challenge to the benefit cap in its application to all lone parents and their children, i.e. the majority of those affected by the cap, which is over 70%, how that could be framed as a voluminous discrimination challenge, where what had to be justified was a lack of any exemption for this group, as opposed to it being an indirect discrimination challenge, where what had to be justified was the introduction of a measure which had such disproportionately adverse impacts on lone parents and their children. And to this day, I still can't quite get my head round the way the case evolved in the Supreme Court and the almost lack of ownership we had over it. However, with a bit of distance, there are some positives from DA. The first was the finding that the benefit cap and the benefits it related to was within the ambit of Article 8 and the right to private and family life. And this is hugely significant because traditionally benefits have been viewed purely through the Article 1, Protocol 1 lens as possessions. And so while there's no right to any particular form of social security, if social security provision is made, it must be done on a non-discriminatory basis to avoid breach of Article 14 in conjunction with A1P1. But where does this leave children? Child benefits isn't paid in the name of the child. The child themselves have no legal entitlement to child benefit. Similarly, child tax credit is for the benefit of the children, but it's paid to the person responsible for them. It's only disability living allowance, which is actually paid in the child's name and to which they have legal entitlement. So an A1P1 possession lens leaves the interests of the children out of the equation, even though the benefit might be paid for them. And so viewing it in terms of Article 8 and right to family life allows the interests of the children to be in play. So that was the first really significant thing that came out of DA. The second positive, and which is related to that Article 8 ambit, was the role of the UN Convention on the Right to the Child, and particularly Article 3.1, which concerns the obligation to give primary consideration to the best interests of children in all actions concerning them. This article had previously been considered in the case of McLaughlin, which concerned discrimination in relation to widowed parents' allowance in regard to those parents who weren't married to their deceased partner. And there, the Article 3.1 UNCRC was seen as reinforcing the finding of Article 14 discrimination. However, in DA, we go several steps further than that. Not only, it wasn't seen as just reinforcing an Article 14 finding of discrimination, but in DADS, how they played a key part to the Article 14 justification analysis. We were finding the decision had not been made in substantial compliance with Article 3.1 may well be manifestly without reasonable foundation. So an unincorporated treaty, provision of an unincorporated treaty needed to be considered in relation to justification under Article 14. So a bit of licking wounds, but some positives 2 years ago. If we'd had this talk 1 year ago, I would have been on a roll. Yes, so at the beginning of last year, we had the case of Jackson in the High Court, where the McLaughlin, which related to widowed parents allowance and the Article 14 analysis there was applied directly to something called bereavement support payment, which replaced widowed parents allowance in 2017. So Article 14, clearly in play in relation to social security rights. We then had something called Reynolds, TD and AD in the Court of Appeal, which concerns people who claim UC after they've had this decision ending their entitlement to legacy benefits, so to income support, to job seekers allowance. But the only reason why they've had their entitlement to those benefits stopped is ultimately found to be wrong. It's an erroneous decision. They should have remained entitled to it. But because their entitlement has been ended and the benefits terminated, they've had to claim universal credit. So they've got something to live off in the meantime in what was they're challenging the ending of the legacy benefit. And for certain people, particularly disabled people, they might find themselves worse off financially under universal credit than under legacy benefits. And so you have a group of people who they go on to successfully challenge the decision ending their legacy benefits, but they can't return to legacy benefits having claimed universal credit because of something called the lobster pot principle, and yet they find themselves worse off in UC. And so we brought a challenge to that. We were unsuccessful in the High Court, but we were successful in the Court of Appeal on an issue of status, which, having listened to Xu Xin, yeah, government conceded status in the Court of Appeal, that the relevant status was somebody who'd had their legacy benefits terminated because of an erroneous decision. It's slightly difficult to see how that has some independent existence from the differential treatment which is being complained about, but the point was conceded, at least the Court of Appeal. And in a powerful Court of Appeal judgment, Lord Justice Singh emphasised that what has to be justified in relation to a discrimination claim is the difference in treatment. It's not just enough to show that the underlying policy is justified, but it's a difference in treatment that needs to be justified. And in referring to this, he relied on Lord Bingham in A versus Secretary of State, the Home Department. And then in relation to justification, this was one of the first cases since DADS and the Supreme Court and its single manifestly without reasonable foundation question. And Lord Singh chose to adopt the approach in the Court of Appeal in the two-child rule case, which had been given shortly before DADS was handed down, and where Leggett, in trying to reconcile manifestly without reasonable foundation with the traditional proportionality analysis, said that what is required is whether the difference in treatment is manifestly disproportionate to the legitimate aim. And Lord Justice Singh applying that analysis concluded that the difference in treatment between the group that had their legacy benefits wrongly terminated, the difference in treatment was manifestly disproportionate in its impact on the appellants. So in some way, despite the concern in relation to DADS and the single comprehensive manifestly without reasonable foundation test, was it such a big issue? Yes. And we see in Reynolds TDAD that in fact it might be, that it might not be, that there's still a proportionality analysis going on. But then to note in relation to Reynolds and the issue of status and what Xu Xin was saying, that Secretary of State sought permission to appeal direct to the Supreme Court, having conceded status at Court of Appeal, and she sought to reopen the issue in the Supreme Court. Permission was refused, and in refusing permission, the Supreme Court said that while status in Article 14 might not be as clear as it could be, it had been thoroughly considered domestically in Stott and had been re-examined more recently by an enlarged constitution of the Supreme Court in the child rule case. So that's the SC case, which was heard last October and on which judgment is still awaited. So it might well be that that's used as a vehicle to pronounce, on status yet again. And then last year, continuing on the roll, we had a case of Johnson, which concerned universal credit again, and regularly paid monthly employees who lost out quite considerably in how much universal credit they were entitled to, purely because of the proximity of their pay dates and when their universal credit assessment periods started and ended. And we tried to frame this as an Article 14 discrimination challenge, as well as an irrationality and a Padfield challenge. In the High Court, it had been taken as an interpretation issue, and then when it had been appealed by the Secretary of State to the Court of Appeal, it was taken as a rationality issue, whether the treatment was irrational or not. And even though we'd pushed for an Article 14 analysis, the Court of Appeal had stuck with considering it as irrationality. And that in some ways was, whoa, okay, so challenges to secondary legislation wouldn't be possible in relation to primary legislation, but challenges to secondary legislation, can we potentially cut through the problems with status and the problems with justification with Article 14 by going down the common law irrationality and giving new life to that, particularly in view of the wider politics around and Human Rights Act. And that seems to be the case, briefly, momentarily, in a decision shortly after Johnson, a High Court decision in a case called Pantarisco, which concerned people who were benefit capped purely because they were paid by their employers for weekly rather than monthly, and so they didn't receive enough income each month to get over the threshold of earnings, so the benefit cap exception. The Johnson analysis in relation to irrationality was applied directly. And so while we had framed the argument or it could be potentially framed as both a rationality and a discrimination argument, the status in relation to discrimination being those employees who are paid for weekly rather than monthly. The court was again happy to go down a rationality analysis. And then if I can have my first slide, please, there was a bit of more detailed case law that I wanted to bring you to. So this was the case of Moore that Shushin's already referred to, and this was Swift in the High Court. And this concerns statutory maternity pay and maternity allowance, and the fact that they're treated very differently in UC, with the result that a woman might be, 400, 500 pounds worse off because, she qualifies for maternity allowance rather than statutory maternity pay. Maternity allowance is deducted pound for pound from universal credit, whereas statutory maternity pay is subject to something called a work allowance. You can hold a certain amount of that income, and then after that, it's subject to a 63% taper. And so you have Swift in Moore saying, I do not consider that the complaint in this case naturally lends itself to an Article 14 discrimination analysis, even though the discrimination was a difference in treatment between women who received maternity allowance and those who received SMP. The point of substance is whether there's an appropriate reason for treating MA as unearned income while treating SMP as earned income. That issue better presents itself as one of rationality. I cannot see that the required level of scrutiny is any different regardless of whether the claim is analysed as one of Article 14 discrimination or one of common law rationality. So there, potentially, following on from Johnson and Pantalrisco, we've got irrationality is the new kid on the block rather than Article 14 discrimination in relation to secondary legislation cases. But then looking at things this year, my role has come to an end, and very much this year, my head is in my hands. So in relation to two-child rule, we had the hearing back in October. We're almost a full judicial year on from that, and we still haven't got a decision. But in view of what was said in the refusal of permission to appeal in Reynolds, it looks very much like the two-child rule case will be hijacked by their lordships, not to pronounce this time on justification, but this time to pronounce on status. And also from some of the comments that were made in the hearing, it will be really interesting to see whether Wilson's approach to the relevance of Article 3.1 UNCRC to having a direct role in Article 14 justification, whether that analysis will stand. But as an aside and to note, in the Secretary of State's submissions in the two-child rule case in relation to justification and manifest without reasonable foundation, she was of the view that ultimately the MRWF test is no different from the usual balancing exercise in assessment of proportionality. So again, the concerns that were immediately raised after DADS are perhaps not as heightened as they needed to be. Then looking at Pantalrisco, so this is benefit cap for weekly paid case, which was successful in the High Court. Secretary of State's appeal in that case was heard 2 weeks ago. And while judgment is still awaited, from my attendance at the hearing, it's very unlikely that the High Court's decision will be upheld. There was criticism by the Court of Appeal of the rationality approach in Johnson being just used as a checklist. And then we get to Moore, and again, so we appealed this case, with Shushin. We were in court last week for an oral hearing of the permission to appeal application. And the concerning issue here is that, as Shushin has stated, sort of somehow we get into the differential impact not needing to be justified, but rather just the rationality of the measure itself needing to be justified. So if I could have the next slide, please, Ramonda. So here, this is what Swift was saying in the High Court and his concern about the concept of other status. And if other status is extended beyond characteristics that exist independently of the complaint to matters which coincide with the decision challenge, it must be accepted the decision taken was directed to a class of people because of the characteristics of that class. The question becomes whether that is a permissible or justifiable reason for that treatment of that class. This is not a question about discrimination in classic sense, rather it is a question about the rationality or justification of specific policy choice. In situations where the court has determined Article 14 claims, where the other status relied on seems to be closely aligned with the scope of the measure complained of, the decision on the legality of the measure has tended to rest on whether there was a sufficient reason for the measure imposed on the class. And so having taken that approach, Swift then goes and asks himself whether there is, a sufficient reason for SMP, for statutory maternity pay, being treated as earned income. And he finds that there is. And he finds, that that's perfectly acceptable. And, we weren't challenging the reasons for treating SMP as such, but we were saying that, you had to look at the differential impact of that different treatment. You have to look at the impact on the two groups of women and whether that impact was justified. So in relation to what was said in Reynolds, whether there was a manifestly disproportionate impact on the group affected. And so, in view of the fact that there seemed to be no analysis of the differential treatment itself, as opposed to the justification for treating SMP as such, we sought permission to appeal to the Court of Appeal. And in a judgment, which was an extempore judgment last week, the approach of Swift was very much endorsed. According to Lady Justice Simler, read as a whole, the judge considered the difference in treatment was what had to be justified. There's no doubt he had regard to the impact of the difference in treatment, and not persuaded did not apply justification and proportionality analysis. So it seems that we're now looking at the rationality of the measure without any regard to its differential impact and whether or not that is proportionate to any legitimate aim. But doesn't that reduce us to justification for the measure or the policy rather than justification for its discriminatory effect, contrary to what Lord Bingham said in A? In Johnson, where rationality analysis was favoured over discrimination 1, the perverse consequences, i.e. the impact of the measure being challenged, were part of the rationality analysis. In Moore, this appears to be stripped away altogether, and real concern that approach has been endorsed by the Court of Appeal in refusing permission to appeal in Moore. So head in hand, and very much I would like to be coming back to this, talk in a year's time to see what the state of play is post the Supreme Court decision in the two-child rule case, and how much what is said there is followed by the lower courts or not, and whether SC itself, assuming that we are unsuccessful in it, being realistic, whether that goes up to the European Court of Human Rights and what they will say on the issue as well. So very much a continuing evolving picture. Thank you.
Thanks very much indeed, Carla. The next speaker is Mike Spence at Mike Spencer, who's a Deputy Street Barrister in public law, who's a rising star in the areas of asylum, immigration, welfare benefits. He was previously a solicitor at CPAG and the Asylum Supports Appeals Project for a number of years. His recent successes include the case of SK, which was about access to maternity grants for refugees, Akin Sanya, on Zambrano carers under EU settlement scheme, and DK, which was on backdating tax credit for refugees. He's going to do a talk on discrimination against refugees.
Thank you, Adam. Ray, could you move to the first slide, please? So anyone who works with or lives with or is a refugee is aware of the reality. And that's that asylum seekers and refugees suffer significant economic disadvantage and economic barriers. And that arises partly because of the forced destitution policy in the UK, the hostile environment, partly because of the inherent situation of refugees. Apart from a few oligarchs, the vast majority of them will have left their country with no possessions whatsoever. And also because of the attributes that many refugees have. In particular, many have been victims of trauma. Most don't speak English very well. Many will have been victims of trafficking. And for all of those reasons, they face difficulties in in accessing economic advantage in the UK, even after the grant of refugee status. If we can turn to the next slide. However, we're up against the perception, and that's that any attempt to give refugees favourable treatment is somehow inherently unfair. And I think this headline is quite interesting, really, because the assumption behind the headline writer is that asylum seekers not only should not be at the front of the queue when it comes to vaccinating, but also essentially should be at the back of the queue behind British people. And there's an assumption there that asylum seekers are not vulnerable, notwithstanding also all the other reasons why it might be necessary to vaccinate a group of asylum seekers ahead of British people, particularly if they're housed in accommodation together, essentially in detention, without being able to have any choice about where they live, and all the public health reasons why you might want to vaccinate them first. That leads me on to a legal question, which I'm going to look at in this talk. If we can turn to the next slide, please. Which is a question I phrased myself, which is essentially, to what extent can equality law require on the part of the state positive action to protect refugees from structural disadvantage? And I'm going to focus mainly on economic disadvantage, and I'm going to attempt to answer that question by looking at 4 recent examples in the case law. Next slide, please. Before we do that, I think we should look over the essential legal framework and the provisions that apply when you're considering whether refugees are suffering discrimination. So first and foremost, next slide, please. Article 14 of the European Convention on Human Rights, which Shushin and Carla have talked about. There's 2 features that I think are important when it comes to this discussion. First, the question of other status, and the European Court has indicated that refugees do form another status for the purposes of Article 14, and indeed are likely to fall within one of the more central of the concentric circles that Shushin was referring to. But also within the status of refugee, there may well be other statuses, and we'll come and have a look at that when we look at some of the cases. Second thing I just wanted to highlight is that Article 14 talks about prohibiting discrimination, but that doesn't mean that everybody must be treated equally or treated the same. It also includes an obligation to treat different cases differently, and we get that from the very important case of Thalimenos, which is my next slide. So this is a formulation you see throughout from the European Court in the case law under Article 14. It's not just about treating people the same or not treating people differently on grounds of other status. It's also about treating an obligation to treat them differently. And if we turn to the next slide, how the court formulated it in DH in the Czech Republic, sometimes a failure to attempt to correct inequality through differential treatment may itself constitute a breach of Article 14. Domestically, we have the Equality Act, if we can turn to the next slide, please, which has many provisions, which I'm not going to go into in detail. It's quite a complex piece of legislation, but I wanted to focus particularly on the definition of indirect discrimination in the Equality Act. And that's where, in a way, that's a way of achieving the Thalimenos analysis through a different means or a different way of looking at it. And where you have a rule, a provision, criterion, or practice, which on its face is not discriminatory, applies to everyone equally, it may still be indirectly discriminatory where it places a particular group with a protected characteristic at a particular disadvantage. Now, refugee status is not itself a protected characteristic under the Equality Act, but the courts have held that a rule that disadvantages refugees also may disadvantage non-UK nationals and therefore may be indirectly discriminatory on grounds of race. In terms of international provisions that are unincorporated, if we can turn to the next slide, we have, of course, the Refugee Convention, and that itself contains a number of equal treatment provisions. and for the purposes of social welfare, Article 23 is relevant. It talks about public relief and assistance, and that's broadly interpreted to include most social security benefits and also other forms of social welfare, such as housing. And again, although it talks about the same treatment, necessitates the same treatment for refugees as compared to nationals, that doesn't necessarily always mean equality of treatment, can also mean equality of results. And then finally, it's worth mentioning on the next slide, the Qualification Directive, which is retained law, but has less application now that we've left the EU in terms of its power to disapply primary legislation. But it's framed very much in similar wording to Article 23 of the Refugee Convention. And it talks about the necessary social assistance being provided to nationals. Importantly, both of those provisions, Article 23 and Article 28, only apply on grant of status, so where status is recognised, and don't apply to the asylum seeker on their initial application in the UK, and that's obviously very important. Finally, I just wanted to make a note on the next slide in relation to other status, the case of Hoden Abdi. There you can see that the status can be subdivided, and in that case, the discrimination was in fact between two groups of refugees, those who married before leaving their country of origin and those who married after. And the court said there was no justification for the difference in treatment between those two subgroups of refugees, and importantly noted that the fact that the UK had introduced the rule in favour of those who had married pre-flight in order to comply with its international obligations doesn't justify necessarily the differential treatment in relation to those who married post-flight. Okay, we're now going to look at my 4 examples. So if we can turn the slide, please. First is a question about backdating benefits. And as some of you who have been around for some time may remember that it used to be possible to backdate income support on grant of refugee status to the date on which the claimant claimed asylum. That's the regulation there. And essentially that provision was a piece of positive discrimination in that, or certainly an attempt to alleviate discrimination, in that it put the refugee, having been notified of their status, in the same position they would have been had they had status on arrival. That was then abolished, and unfortunately, next slide please, the Court of Appeal in a case called Blakesley held that that did not constitute a breach of either the EU directive or Article 14. Now, the Article 14 analysis in Blakesley was quite short, and I think personally wrong. And really, this paragraph is the sum of how they dealt with the discrimination point. And the court said, well, there's no analogy between asylum seekers and British citizens because asylum seekers are still having their claims determined. And that's, of course, obvious. But the real question in this case was whether there should be an analogy between asylum seekers who are genuine refugees and later have a grant of status, and those who aren't. And what's the justification for not putting those refugees who have had their status recognised into the same position they would have been had they had status all along? And that question again arises in another case in relation to tax credits, which Adam mentioned at the beginning of his talk. He mentioned it as a success, which is a bit preemptive because we haven't had the judgment in that case yet. But do watch that space, and it may well go on back on up to the Court of Appeal. If we can turn to the next slide, please. Right, next, second example is we have a rule here in the DLA regulations, that's Disability Living Allowance, which says you have to have been in Great Britain for 2 years, 2 out of the last 3 years in order to qualify. So we have a neutral rule on its face, which obviously has a disproportionate impact on refugees. And not just refugees, in this case, it's a subclass of refugees who are entitled to DLA, and that means refugee disabled children. So there's a sort of 3-pronged disadvantage to their status. Interesting thing about these types of rules is that in reality, often they are a form of disguised discrimination, in that although there was no intention to single out refugees, certainly the intention was to introduce a neutral rule, which would have the effect of removing entitlement for many non-nationals, which would include refugees. If we turn to the next slide, please, in a case called MM and SI, the upper tribunal accepted that this neutral rule constituted discrimination under Article 14. And looking at when it came to justification, the court looked at the rationale for the rule, which was to establish a link with the UK, and pointed out that that rationale can't have any application when it comes to refugees. And that's because refugees have absolutely no choice about where they live, and they've got no choice about whether they can return to their country of origin. So while the rule may have some rationale for example, returning British nationals or other foreign nationals, refugees are in a special case. And they've already established their link with the UK by being granted refugee status. So that's a very helpful and important acknowledgement from the court that such rules can't apply or can't always apply to refugees. Next slide, please. Second, we have another case here, a very apparently innocuous neutral rule, which says that, well, the objective of this rule essentially, and this is one of the coalition's government's cuts to benefits, was to say you should only get a maternity grant, which is a £500 grant that can be granted to new mothers and new mothers with young babies to pay for essential baby items like prams, etc. And the coalition government wanted to introduce a rule that said, well, you can only get that grant for your first child. But the difficulty was how to formulate that rule in a way that was effective. And the way they chose to do that was to say that if you already have an existing family member who's under age 16 in your household, then you can't get the maternity grant. Now, having made that rule, the government then found themselves in the position of having to make various exceptions for all the obvious people where there is an older child, but there's absolutely no basis for saying that the mother would have been able to, well, either had a maternity grant before or would have been able to purchase maternity items before. So, for example, kinship carers, twins, and various other groups had to be accepted from the regulation. And so then we brought a legal challenge on behalf of refugees. If we turn to the next slide, please. And the argument there was refugees are not going to be in a position, refugee mothers are not going to be in a position where they have baby items because they're not going to be able to leave their country of origin with a pram in tow and all the various other things that you might have bought with your £500 maternity grant. And so the aim of the measure doesn't achieve its objective. And the court went even further and said, well, it doesn't even, not only does it not achieve the objective, it actually defeats the objective because it denies the support to the claimants who are likely to be among those most in need of it. And since the government's stated rationale for introducing a rule restricting to maternity allowance was to focus the support on those who need it most, by applying it equally to refugees, that rationale broke down. And so it was necessary for the government to make an additional exception amongst the many for refugees who have had their children in the UK post-flight. Sorry, I think I'm on my fourth case, which is the last illustration now, which is the Hillingdon housing allocation policy. Similar again to the past presence test. Here we have a local connection rule from the local authority saying you can't be eligible for being listed, putting on the housing list, essentially, if you haven't been in the borough continuously for 10 years. And again, we have a neutral rule that clearly has a disproportionate and prejudicial effect to refugees in particular, as well as other groups. And there were two main legal challenges, one on behalf of Irish travellers and gypsies, who are obviously disadvantaged by this provision, and also on behalf of refugees, and they were considered together. Sorry, before that, the refugee case was considered separately in the administrative court. So if we can turn to the next slide. And Mostyn J, this was a case under the Equality Act because it was a policy that was being challenged. Mr. Justice Mostyn didn't consider that even that there was discrimination against or indirect discrimination on grounds of nationality as a result of the rule, going against their Hillingdon's actual concession that there was discrimination. He said there was no discrimination, but also in terms of justification, he said there is no less intrusive means, because once you water down the measure by introducing a special rule for refugees, you're making special treatment. So we're going back to the vaccination story in the Evening Standard, where the court's saying, you make a special rule for refugees, that's not fair. And the Court of Appeal disagreed with that. If we turn to the next slide, applying very much the reasoning we saw from the upper tribunal, because unlike economic migrants, asylum seekers have no choice about where they live. And during the pendency of their applications, they're accommodated by the Secretary of State under the 1999 Act, and they have no choice about where they're placed. And so a refugee is vulnerable to be moved against his will, and the consequence is that the justification for having a 10-year rule can't apply to them. If we turn to the next slide. And then the Court of Appeal confronted Mostyn's sort of concern about special treatment. And he says, well, you can, the Court of Appeal said, you can make a special rule for refugees. Since they're not themselves a protected group, you wouldn't be discriminating under the Equality Act. And in any event, by making that special rule, you then mitigate any disadvantage suffered on behalf of non-UK nationals as a class as a whole. And then that residual discrimination might be capable of justification because other non-UK nationals are in a different position to refugees. So if we can turn to the last slide, please. Hopefully I've answered my legal question, and I've given a slightly facetious answer there to say that the extent to which equality law can require positive action in the UK on behalf of refugees is quite a lot. If I'm to give a more detailed analysis of that, I think it's fair to say that the court recognises, or the courts recognise, the special status of refugees and the economic disadvantages they suffer. And the decision makers are required to consider making special provision, be that by way of an exception or by way of a special rule, for refugees to prevent that disadvantage. Thank you.
Brilliant. Thanks very much, Mike. That's excellent. And so I have the last talk now, and my talk is on a couple of issues that I thought were interesting in recent case law regarding two topics. The first one of them is Article 14 justification, which Carla has already looked at to some degree. And the second one is disability discrimination. So looking at Article 14 justification first, excuse me for a moment, I'm just adjusting the gallery. Article 14 justification first. So just to recap, Article 14 discrimination cases normally pose 4 questions. Do the circumstances fall within the ambit of another convention right? Has there been a difference in treatment between two groups who are in analogous situations? Thirdly, is there an other status? Is your claimant a member of a group which is another status? And fourthly, is there a justification for any difference in treatment? I'll just quickly run through a couple of points about the first 3 questions. Ambit is increasingly widely interpreted. There are a few cases which have failed on the basis that the issue doesn't fall within the ambit of another convention right. And more recently, a number of higher court decisions have indicated that a more than tenuous connection is sufficient, a more than tenuous connection to the core values of one or other convention rights is sufficient to mean that the measure falls within the ambit of that convention right. And just to pick a few examples of what falls within the ambit, free legal advice for immigration detainees, restrictions on work that victims of trafficking could do, and even critical comments on a Facebook page have been held to fall within the ambit of a convention right. Now, I should mention that I've hopefully some seminar notes from me have been distributed to you, and I'm referring to those. Those have got a number of footnotes which have the authorities which I'm relying on, so I'm not going to refer to those authorities in any detail during this talk. So the second question, the analogous situation question, again, like the ambit point, the courts are giving an increasingly relaxed approach to this. So although there is a difference of approach to whether or not analogous situation is an important factor, a number of recent senior decisions have indicated that unless there's a very obvious difference between the two comparator groups, then it's better to focus on justification. Other status, the third question, Shushin's already dealt with that. And so I'll move on to justification. In many cases involving Article 14, this is now the key battleground, given that the first three questions are increasingly easy to satisfy for a claimant. And again, for justification, there's another four-stage test, or at least there's ordinarily a four-stage test. And this has already been described by Carla. Just to recap, legitimate aim is question 1. Is the measure rationally connected to it? Question 2, is it no more than necessary to accomplish the legitimate aim? Question 3. And fourthly, the fair balance question. Is it a fair balance between the impact on the individual and the rights of the community? I'm not going to deal with all of those questions. There's an overlap between them. So sometimes the answer to the first three in particular might be relevant to the fourth one. So for example, if the court has doubts about the answer to the first three questions, then those might be relevant to whether a fair balance has been struck. Looking at question 1, there's been certain recent cases which have been of interest in respect of whether the legitimate aim test is satisfied. Now, it's often pretty easy for the government to show that there's a legitimate aim, but there have been a number of interesting recent cases where the government's failed to do that. So to give some examples, this is paragraph 5 of my notes. The examples of cases in which the courts have decided that the legitimate aim question wasn't satisfied includes no legitimate aim was put forward by the government, or the aim that was put forward wasn't considered to be sufficiently important. And the case of Steinfeld is an example of that. That was the challenge to civil partnership legislation on behalf of straight couples who wanted to be able to enter into civil partnerships. The legitimate aim put forward by the government was that they wanted to see what the impact of civil partnerships on gay couples was before making a change. And the Supreme Court said that that's just not a sufficiently important aim to justify discrimination against those of a particular sexual orientation. It wasn't intrinsically linked, was another way that they put it, to the discrimination. Another example is that, and this crosses over with the second question, the aim put forward by the government didn't actually do anything the measure did not actually do anything to achieve the aim put forward by the government. So for example, in Gillam against Ministry of Justice, there was a challenge to the exclusion of district judges from whistleblowing protections. And the justification for that was put forward was that this enhances the independence of the judiciary. And the courts rejected that, Supreme Court rejected that, saying that essentially there was no evidence that excluding judges from whistleblowing protections enhanced the independence of the judiciary. Other reasons that the courts have found that this stage 1 test wasn't satisfied, where the aim in court wasn't the actual aim. Looking through Hansard or the government decision-making papers, a different aim was actually being put forward at that stage to the one that the defendant was trying to rely on in court. Or where there's a conflict between two aims. So JD and the United Kingdom, the European Court recognised that two aims had been put forward for the restriction on benefits, effectively, that was at issue in that case. It was a bedroom tax case. One of the aims was to reduce cost, essentially. And another aim, though, was to protect victims of trafficking. And the European Court held that the government hadn't put forward sufficient reasons to explain why it prioritised the first aim, cost, over the second one of protecting victims of trafficking. And that was a central reason as to why justification was rejected. One issue that often comes up in these challenges is cost. Is cost a sufficient justification for discrimination. And there's a very useful series of paragraphs in the case of TP in the Court of Appeal, which Carla mentioned earlier, where the Court of Appeal sets out the relevant authorities and says that cost isn't a justification for discrimination, at least in the context of the suspect ground, so that's sex, race, nationality, and so on. If the government wants to save costs, they can, but they have to do it in a way which isn't discriminatory. Now, there are some cases which say that, at least in the context of non-suspect grounds, so age discrimination, for example, non-core grounds, then cost can be at least a justification for discrimination. And there's a bit of a conflict in the authorities about that. Burden of proof was mentioned in one of the questions earlier. Under section 136 of the Equality Act, there's a reverse burden of proof where if the claimant shows a prima facie case of discrimination, the burden then goes to the defendant to either show that it wasn't discrimination or that the discrimination was justified. And there's a similar but not identical approach that's applied in Article 14. So in general, it's for the government to prove that a measure was justified. So the government normally has the burden of proving that. There's a slight qualification that I'll come to later. But in general, that's the government's job, and often they will have to do that by putting forward evidence. So evidence to substantiate the justification that they've put forward. And there are a number of examples of cases where the courts have rejected the government's justification and found that discrimination wasn't lawful because the government didn't produce evidence to support it. And a few examples are Brewster is quite an important one in the Supreme Court, where the government's justification was to save cost, or at least to make the scheme more administratively workable. And the Supreme Court said, you haven't given us any evidence to show that this particular measure that was challenged in that case, it was a nomination requirement in respect of a certain benefit. You haven't given us any evidence to show that this would make the scheme more administratively workable. And there's a whole series of other examples of that that are in the footnotes in paragraph 7 of my talk. But a classic example is the Equal Opportunities Commission case, where the government said, removal of protections from unfair dismissal for part-time workers. So removal of those, so part-time workers can't benefit from those. That was justified because it meant that there would be more part-time work. And the House of Lords said, well, you haven't given us any evidence to prove that's the case, and so your defence fails. Now, it's not in every case that the government has to produce evidence. There's a couple of cases which have indicated that there may be situations where common sense or logic is sufficient and evidence isn't necessary. But do go down that route. If the government's saying, well, this measure is justified because of X, Y, Z, do test it and consider whether they've actually proved that. There's another situation which relatively recent cases have indicated that there may be a reverse burden of proof in Article 14 cases. And that's where the government is in possession of the relevant information and the applicant or claimant isn't. And in that type of case, the burden of proof isn't only on the government in respect of justification, but there may be also a similar approach to section 136 of the Equality Act, where if the claimant puts forward a prima facie case of discrimination, it may be for the government to prove that there was no discrimination. And one example of that is the case of Sinter and Romania, where basic facts indicated discrimination. So there was a man who had been prevented from having contact with his child, and he had mental health problems. And the basic facts indicated that this may have been discrimination on the basis of mental health problems. And the court said the burden therefore shifted to the government to show that there was some good reason, not related to mental health problems in general, for the mistreatment. Now, that can be quite useful. It hasn't been developed much in domestic cases, but if you think about challenges to policy or law, often the relevant information is within the hands of the authorities and the claimants don't have access to it. I've been involved in a number of challenges involving the DWP, and the assessment process for vulnerable claimants. And in that context, there's a lot of particular parts of that policy which indicate prima facie discrimination. So, for example, claimants with mental health problems being refused benefits in dubious situations and coming to harm, where the basic facts sort of put forward a case for discrimination, but you don't know whether there was discrimination unless the government produces its actual reasons as to why those individuals were treated like that in those cases. And you might be able to use this run of case law from Strasbourg, at the very least, to obtain disclosure from the government as to the reasons why those policies were applied in the way that they were. Now, I'm conscious that I don't have a huge amount of time left, and obviously we're 15 minutes now into the hugely important game. So I'm going to skip over a few aspects of my notes and go on to the disability and just quickly summarize them and then go on to the part of it about disability. You'll see when reading my notes, I'm sure later on this evening, that I talk firstly about the other aspects of justification and then go on to consider the rise and fall of the manifestly without reasonable foundation test. Now, Carla's already talked about this. I think the basic point is that up until recently, manifestly without reasonable foundation was applied in some contexts and not others. And it was considered that that test would apply dependent on the nature of the matter challenged. So, for example, if you had an issue involving something controversial, legislation, economic and social policy, then that test might apply, if not. That's a very basic summary. But more recently, the courts have begun to recognise, at least, that it's a much more complicated picture than that it's a much more nuanced picture than that. That it's not a binary question, manifestly without reasonable foundation or not. One has to take into account all of the factors, all of the relevant factors, in deciding what scale, what place on the spectrum the case falls, how broad a margin of appreciation the court should give to government. And the factors that may be relevant to how much of a margin of appreciation should be given to government are mentioned in paragraph 15 of my seminar notes, but they include the things that you'll be well familiar with for proportionality assessments in other contexts, in public law or EU law, the importance of the right challenge, the severity of the impact, the extent to which the decision maker actually addressed their mind to the question and decided that discrimination was justified. All of the usual factors should be taken into account in deciding how broad the margin of appreciation should be, the margin of discretion should be. And it's not an all or nothing question. So that's manifestly without reasonable foundation. Just done a topic that could probably be talked about for about 3 hours, done in 2 minutes. And I'll just move straight on to disability discrimination. There are three particular developments that I wanted to focus on. The first of them is Article 14. And just to make two really short points about that, Article 14 has certain benefits over the Equality Act, which have already been touched upon, in terms of bringing discrimination challenges. One of them is that it applies to a broader range of statuses than the Equality Act. The protected characteristics under the Equality Act are relatively few, whereas Article 14 applies to an increasing range of protected statuses. Again, Shushin has dealt with this to some degree, so I'll be very quick, but they include the statuses which are protected under Article 14, include mental capacity, particular types of illness, genetic conditions, combinations of statuses. So, for example, a severely disabled person who crosses a local authority boundary, someone who was on legacy disability benefits who was erroneously moved to universal credit. They're very specific categories that are now considered and you can rely on in your discrimination cases. In paragraph 23, I give some recent examples of findings of breach of Article 14, and do so in part to illustrate another advantage of Article 14 over the Equality Act, which is, as Mike has already mentioned, the Equality Act doesn't apply to legislation. So you can't argue that legislation was unlawful because it breaches the Equality Act. And similarly, the Equality Act doesn't apply to decisions by courts or judicial functions, whereas Article 14 does. The public sector equality duty has been applied in a number of recent cases involving disability, in particular in the housing context. And what's interesting about the housing cases is that it has been approached as a very detailed duty that has onerous requirements, which have to be satisfied at each stage of the decision-making process. So in paragraphs 27 and 28 of my notes, I quote from two cases, Hotak and Hack, which essentially said that at each stage of the relevant housing process, whether that's deciding on the suitability of accommodation or another stage of the process, the decision maker, so whether it's the local authority or otherwise, needs to be considering the nature of the disability, the nature of the needs that arise from it, the relevance of that to the particular question being asked at that time, whether adjustments need to be made, whether someone needs to be treated more positively in making that decision. The main point is that these decisions indicate this is a really detailed and onerous duty. Now, what's interesting is the extent to which those conclusions can be carried over into other areas. So, for example, DWP policy on assessment of vulnerable claimants. In many ways, that policy doesn't require decision makers to have regard to disability in certain contexts of that assessment process. Can you rely on the housing cases to show that the decision makers need to be paying more attention to disability and need to be making adjustments on the basis of it? Hopefully, yes. The last area that I'm going to briefly touch upon before finishing is challenges to policies, where again there have been some recent interesting cases in the disability context involving challenges to government policies. And in short, one of the bases on which you can challenge a government policy is if it gives a risk of unlawful decision-making in a significant number of cases. It's put in different ways in the authorities, and some of them say that a policy will be unlawful if it gives a materially misleading impression of what the law is, or it's also said a policy is unlawful if it permits or encourages unlawful decisions, but it really comes down to the same thing. I mentioned a couple of cases in my seminar notes which have dealt with this, two of which have found that a government policy, pretty important government policy, was unlawful. One example is the case of IJ brackets Kosovo, which was about victims of trafficking and a policy on whether they should be permitted to work. And the court indicated that if the relevant policy didn't say that there's a discretion to allow victims of trafficking to work, then the policy itself would be unlawful. So the law is that there is a discretion. The policy has to make sure that that law is sufficiently clear. And the court said that if it didn't identify that discretion, then the policy itself would be unlawful. A case the other way was Turner, which indicated that a policy on the DWP assessment for limited capability to work wasn't unlawful, and it was to some extent turning on its head the last case that I mentioned, the IJ Kosovo case. But in that case, I represent the claimants in that case, and we've applied for permission to appeal, and so hopefully something positive will happen in the future in that context. I'm sorry that's been such a whistle-stop tour through a number of complicated subjects. That's the end of our talks now, but we can turn to questions before finishing. I noticed that we've had 4 questions which have come through the chat during the talks. The first 2 were relevant to Shushin's talk, and so perhaps Shushin, do you mind if I ask you to look at those? The first one was, how is discrimination combated against acts of private actors?
Well, in the context of Article 14, you know, you have to be a public authority in order to be the subject of an Article 14 claim, because it's claimed under the Human Rights Act, and the Human Rights Act requires public authorities to act in compliance with the HRA. And so from that perspective, I guess I can only just imagine there being hybrid cases. And obviously, so I'm not really sure exactly what that question is directed at, but in terms of acts against private actors. I mean, that's sort of where I want. Did you mean the second question in terms of the reverse burden provisions? I mean, I think that's something that, am I looking at them in the wrong direction, Adam?
Sorry, I'm sure it's my fault.
Because I was like,
first question, if we're focusing on the private, to what extent does Article 14 discrimination impact on private individuals? Yeah. I'd understood. I mean, one I suppose one approach to that is that a starting point is to ask whether the act in question is actually private, and there's as to whether a public function, whether something amounts to a public function, and that's increasingly broad. So you might want to think about, is this?
Yeah. Although I think it would depend, because the public authority and hybrid public authority case law is a bit up in the, it's not as clear cut. It's not just purely on the basis of whether or not you exercise a public function. I know that Mike and I both were involved in some cases relating to, for example, not in the Article 14 context, but in terms of the imposition of curfew conditions in contracted accommodation that's contracted by the Home Office with a private contractor. So who becomes liable for the unlawful act? And the case law on private hybrid authorities, I mean, if you're going to allege an HRA claim, then you've got to establish that this is a target of someone who is going to be a public authority within the meaning of the Human Rights Act. And that depends on whether or not you fall in the line of cases with Aston Cantlow and YL and etc., as to whether or not you are exercising a separate function that can be constituted solely as your function as a private body exercising a public function, or if you are actually not in control of the ultimate decision in terms of the public outcome. And so it doesn't seem, I'm a little bit uncomfortable giving a generic answer to it, because it's quite a complicated line of cases, and it really turns on the facts and context of the relationship of the private body and the act that is alleged to be a discriminatory act.
It's also obvious to point out that in terms of private acts by employers or by service providers, they would be caught by the provisions of the Equality Act. So you wouldn't necessarily need to rely on Article 14.
Yeah. The second question you were saying that I should take, I don't quite know which one, because the reverse burden one is not an issue that kind of is touched on in my talk.
And hopefully, I briefly touched on that, and I did it in a bit more detail in my notes. So hopefully that's sufficient to answer the second question. Yeah. The third one was came about during Carla's talk from Sean, and the question is, what were some of the reasons given by the judge in ruling that the difference in treatment was disproportionate? I think that referred to the case of TD, but I suppose a broader question to Carla, whether from TD or otherwise, are there particular factors which you think are helpful from the cases where judges have ruled that certain things rendered a matter disproportionate?
No. this is this whole question. This is no shoe-shins, no clear as mud. I think very much it's, you know, judges come at it with, oh, this doesn't feel right. Yes. And if it doesn't feel right, they will find on status, they will find on amber, they will find on analogous treatment, and they will find that there's no justification. Yeah. So in TD, for example, you know, query whether, you know, there was an independent status. In relation to justification, the specific question, you know, the reason why it was considered differential treatment was disproportionate was that, you know, in the words of Lord Justice Singh, the appellants were treated as they were despite their successful challenges to the decision ending their legacy benefits for reasons to do with administrative cost and complexity, which have nothing to do with the merits of their cases. And that the only reason in reality why they moved from legacy benefits to UC was as a result of errors of law by the state itself. Yes, so essentially finds it disproportionate because the individual claimant shouldn't be punished, yes, or shouldn't be worse off because of errors by the state. In relation to the Moore case that both Shushin and I have talked about, where the difference in treatment was differences between SMP and maternity allowance, you know, you could well say that a woman shouldn't be punished, shouldn't be worse off because she changes job at some point during her, you know, pregnancy and therefore qualifies for maternity allowance rather than SMP. So, you know, applying the TD reasoning, you could say that, well, that was a disproportionate impact, but, you know, Swift took a very different approach. So it's difficult to glean, you know, very clear lines, which you can then say, oh, you can identify a case and say, right, that's going to fit within that analysis.
Okay, thanks very much. And Mike, Shushin, please do jump in if you would like to add anything to these. The last question is from Jeremy, which is what role do equality impact assessments play in establishing or defending an Article 14 ECHR claim? Now, a broader question which covers that is what role does a failure to comply with the public sector equality duty play in defending an Article 14 claim? Equality impact assessments aren't actually specifically required by the Equality Act, but complying with the Section 149 PSED is. And there's a very helpful case called Cole, which is a Supreme Court case about probation hostels, which said that that wasn't about Article 14, it was about different types of discrimination, Equality Act discrimination, but it said that the failure to comply with the PSED in that case meant that the Secretary of State could not justify discrimination. Simple as that. And although that applied to Equality Act discrimination, it's the same concept. So it's still a question of whether the Secretary of State had justified an act of discrimination. And there's no reason why that shouldn't apply equally to Article 14 cases. And so it's very useful at the earliest stage in your case to think about a PSED claim, because if you get to the end of the case and you've won on that, and then it comes to the point of justification, you can rely on the failure to comply with the PSED to show everything, you win on everything. So I hope that answers your question.
I would agree with that as a matter of principle and logic and good legal analysis, but I think the problem sometimes arises, and certainly Carl and I have had this recent experience of it, is that raising a PSED challenge, particularly in the social security context, the Court of Appeal has seemingly taken the view that you've got to do it at the point at which the regulations were laid, rather than at the point at which you, the claimant, have been affected by this. And that was the situation in Moore. And that seems to be an analysis by the Court of Appeal that turns very much on PSED as a particular type of case in the context of time limits and limitation. And that does, I think, have a chilling effect, because there is no requirement, like you say, to do an EIA, but there is a requirement to engage with the PSED. I think if you look in the context of the jurisprudence over the last few years about the PSED, and I know that we're planning a further seminar specifically on, is the PSED dead in the water? Because when we look at it in the context of housing allocation cases, eviction, possession cases, and the way the Court of Appeal has dealt with the relevance of the PSED and its strength, it's starting to become sort of sidelined in a way, in circumstances that I think is quite dangerous, because like you say entirely correctly, that this is the high point of how the government thinks about its policy and tries to justify it before producing it and implementing it. And yet, if it's defective, the courts have been very reluctant to really go on a real attack on that kind of rationality and that kind of approach. Therefore, it then has an adverse reverse impact on the way that the court then allows for post facto justification in relation to Article 14 claims. I mean, if you look at the benefit cap challenge, you look at Moore, those are sort of quintessential cases where the PSCD has been sort of sidelined, and it does then seep into the way the court then analyzes justification, as if it's doing it completely afresh and it, you know, all things are in play. I mean, all I'm saying is I totally agree with you. Logically, that would be right. But it seems that the courts haven't really been applying it in that kind of structured way.
Yes, I suppose it depends on whether you're going to get Lady Hale or Swift as your judge as well.
At the moment, it's more likely than not going to be Lady Hale.
Not going to be Hale, which is a shame. On that note, thank you very much for all of our speakers and for Raimonda for organising this. Thank you for attending. I hope it's been useful. From my part, at least, if you have any other questions that you want to ask afterwards, please do feel free to email me. It's a shame that we're not able to meet in person for a drink, but I hope we will be able to do so soon. Thank you.